Hello everyone, welcome back to our channel, Just Immigration News. We hope you're doing great. In this video, we're going to talk about urgent update potential changes to immigration policy. In a significant turn of events, there are emerging discussions about potential changes to immigration policy that could reshape the current landscape. Authorities are considering several key adjustments aimed at addressing ongoing challenges and improving the system's efficiency. This video provides a closer look at the proposed changes and their possible implications. If you are interested in this, so to get all the information, pay attention and watch the video through to the end. Please hit like and subscribe, and don't forget to push the notification bell for an upcoming video. So, without any further delay, let's jump into the video. Urgent update potential changes to immigration policy. As of July 29, 2024, significant discussions have emerged regarding potential changes to U.S. immigration policy, capturing the attention of those considering their immigration status in the United States. Keeping abreast of these developments is crucial, especially for individuals who are contemplating adjustments to their immigration status or those affected by current policies. This video delves into the recent announcements from the White House and the Department of Homeland Security, which outline a series of proposed regulatory changes that could reshape the immigration landscape. The White House Regulatory Agenda. Recently, the Federation for American Immigration Reform highlighted a pivotal release from the White House executive branch, detailing its regulatory agenda. This agenda includes numerous proposed changes to immigration regulations, many of which have been carried over from previous years, while others are newly introduced. The anticipated changes are of particular importance as they could potentially be enacted before President Biden's term concludes. Key proposals for immigration reform. One of the most notable changes being discussed involves the possibility of allowing non-citizens to file for cancellation of removal without first being placed in removal or deportation proceedings. This proposal, if realized, would represent a significant shift in current procedures. Under existing law, cancellation of removal is a form of relief that allows certain non-citizens to avoid deportation if they meet specific criteria. Traditionally, applicants must first be in removal proceedings to apply for this relief. Challenges and opportunities. The introduction of a new policy allowing for the filing of cancellation of removal affirmatively, meaning without prior removal proceedings, would mark a substantial departure from established practices. However, this proposed change faces significant hurdles. Cancellation of removal is a legislative relief established by law, requiring both Republican and Democratic approval. Therefore, any executive branch initiative to bypass the legislative process would need to navigate complex legal and political challenges. The proposed policy would necessitate creative solutions from the executive branch, potentially involving the delegation of decision-making to designated authorities. Despite these challenges, the prospect of filing for cancellation of removal without facing deportation proceedings could provide much-needed relief to many individuals. To qualify for this relief, applicants would need to meet certain criteria, including residing in the U.S. for at least 10 years, demonstrating that their U.S. citizen or lawful permanent resident family member would suffer exceptional and unusual hardship, and maintaining good moral character. Additionally, the current visa allocation for cancellation or removal is limited to 4,000 visas annually, necessitating either an increase in the visa cap or the utilization of unused visas to accommodate more applicants. Enhancements to U visa regulations. Another exciting development involves potential changes to the U visa program. The U visa is designed for victims of certain crimes in the U.S., including violent crimes such as domestic violence, assault, and attempted homicide. Currently, victims of immigration fraud are not eligible for U visa relief, despite the significant harm caused by fraudulent practices. The proposed regulatory changes aim to expand the eligibility criteria to include victims of immigration fraud. This adjustment would address a critical gap in the U visa program and offer protection to those who have been deceived by fraudulent practitioners, whether licensed or unlicensed, in addition to broadening the scope of eligible crimes. There are discussions about revising the certification process required for U visa applicants. Presently, applicants must obtain certification from law enforcement agencies such as judges, police, or prosecutors to proceed with their application. This requirement can be a significant barrier for many individuals, particularly in cases where the crime has not been actively investigated or reported. Adjustments to work permit regulations. The proposal also includes potential modifications to the work permit qualifications, which could have a substantial impact on both individuals and employers. Currently, obtaining a work permit can be a complex and challenging process, particularly for those with uncertain immigration status. Adjusting the qualifications and criteria for work permits could streamline the application process, reduce legal uncertainties, and provide more individuals with the opportunity to work legally in the U.S. This change is particularly timely given the increasing number of state-level laws aimed at penalizing undocumented workers and employers who hire individuals without proper authorization. Simplifying the work permit process would not only support individuals in securing legal employment, but also contribute to tax revenue and economic stability by reducing the risks associated with unauthorized work. Reforms to the adjustment of status process. Another area under consideration for reform is the adjustment of the status process, which involves transitioning from a temporary visa or non-immigrant status to permanent residency. One of the key issues is the waiting period associated with preference dates, which can delay the opportunity for individuals to adjust their status to permanent residency. Currently, applicants must maintain lawful non-immigrant status until their priority date becomes current, which can be challenging and lead to the loss of eligibility if their status lapses. Proposals to address this issue include modifying the filing dates and ensuring that priority dates are consistently updated. Such changes would allow applicants to file for adjustment of status without having to maintain lawful non-immigrant status throughout the waiting period. This adjustment could greatly alleviate stress for applicants, improve the overall efficiency of the immigration system, and enhance job stability for employers by reducing the complications associated with visa renewals and petition refilings. In summary, the proposed regulatory changes outlined in the White House's recent agenda represent significant potential shifts in U.S. immigration policy, from allowing non-citizens to file for cancellation of removal without prior removal proceedings to expanding U-visa eligibility and simplifying work permit qualifications. These changes could have far-reaching effects on the immigration system. The proposed reforms underscore the ongoing efforts to address challenges within the immigration system and provide relief to those impacted by current policies as the Biden administration works towards finalizing these changes. It remains to be seen how they will be implemented and what further developments may occur in the coming months. As the debate over these potential immigration policy changes continues, we'll keep you informed of the latest developments. Stay tuned for further updates as the situation evolves and policymakers outline their plans. For now, this is an urgent reminder of the ongoing efforts to address immigration issues on a national scale. That is all for today in this video. What are your thoughts on this? Please let us know in the comments section below. Thanks for watching the entire video. Hopefully the information is useful to you. See you later in the next video. Till then, take care.
Hello everyone, welcome back to our channel Just Immigration News. We hope you're doing great. In this video, we're going to talk about urgent update potential changes to US immigration policy. On July 29, 2024, significant updates were released concerning potential changes to US immigration policy, highlighting proposals that could reshape current regulations before President Joe Biden's term end. The White House executive branch recently unveiled its regulatory agenda, which includes several key immigration-related changes. One of the most notable proposals is the possibility of allowing non-citizens to apply for cancellation of removal without being placed in removal proceedings first. Traditionally, this relief requires individuals to be in removal proceedings before applying. If implemented, this change could provide substantial relief, though it faces legal and legislative challenges as cancellation of removal is established by law and requires bipartisan approval. Another important development involves the U-visa program designed for victims of certain crimes, including violent crimes like domestic violence and assault. The proposed changes aim to expand eligibility to include victims of immigration fraud, addressing a significant gap in current protections. Additionally, there may be revisions to certification process required for U-visa applications, potentially making it easier for victims to receive the necessary endorsement from the law enforcement. Proposed changes also include adjustment to work permit regulations, which could simplify the application process and provide more opportunities for legal employment. This is particularly relevant in light of recent state laws targeting undocumented workers and employers who hire them. Finally, changes to the adjustment of the status process are under consideration. These changes could address issues related to maintaining lawful non-immigrant status while waiting for priority dates to become current, thus alleviating stress for applicants and improving overall system efficiency. Overall, these potential reforms aim to enhance the immigration system by providing greater relief and simplifying processes for individuals navigating immigration status changes. As discussions continue, staying informed about these developments will be helpful for the citizens.